All right, chapter 6, estates and interests. In this chapter, we're going to identify the characteristics of an estate and land. We're going to learn what that term even means. We're going to describe the characteristics of encumbrances, such as liens, easements, and encroachments. So to start off, what is an estate in land? An estate in land describes the amount and kind of interest that a person has in real property. And there's two categories of estates in land. There's freehold estates, where you're free to hold the property forever or a lifetime. This is the category of ownership estates. And then there's leasehold estates, which are less than freehold. You're not free to hold it forever or a lifetime, but for limited periods of time, as defined in a lease. So in this chapter, we're going to go over the three types of freehold estates in detail. We're going to mention just the names of the four types of leasehold estates. Those we really go over in chapter 12. But I changed the definition here of estate and land versus what you see in the book at the beginning of this chapter, because the beginning of this chapter is particularly talking about the freehold, the ownership category of estates. So the definition that they have talks about the ownership category, and it describes an estate and land as describing the amount and kind of ownership interest that a person has in real property. So I want you to cross out the word ownership in that sentence. You'll see, and we will highlight that sentence here. The amount and kind of ownership, cross out the word ownership. So it just reads, the amount and kind of interest that a person has in real property is an estate in land. And there are two categories of estates in land. Freehold estates, that's the ownership category, and there's three types. And the leasehold estates, there are four types of those. So write those notes and the highlights and the crossing out and take care of that while I'll take my notes here to start the chapter 6. Everybody got those notes, or anybody still writing?
Oh, done.
I'm
Okay.
done.
Got it.
So there are three types of freehold estates that describe the types of ownership. We have fee simple, fee determinable, and a life estate. So let's highlight here. Let's highlight here freehold estates, and then write the number 3 there so it doesn't smudge by highlighting it afterwards. And then we'll highlight the three types of freehold estates: fee simple, fee determinable, and life estate. And the first two types of estates are for an indefinite period of time, and they can be inheritable. The last one, a life estate, cannot be inherited. We'll go over that in a moment. Before we get into the deep details of the three types of freehold estates, I'll just explain to you really quick about the leasehold estates, what a leasehold estate is. Leases involve tenants. A lease signifies the tenant's right to occupy an owner's property for a limited period of time as defined in a lease. So leases involve tenants. The tenant is the lessee. The owner is the lessor. They're the ones that give the lease. A lease is personal property that's considered an intangible or incorporeal asset. It is not considered real property ownership because you don't own the real estate. So that's why it's considered personal property. A lease describes the tenant's right to occupy someone else's property for a limited period of time as defined in the lease, as well as the terms, the length of time, what's being leased, and any limitations on the estate. The lease is what gives the tenant rights. So this is a unique document. This is why when a landlord evicts you, they can't just change the locks and throw your crap out on the street and shut off the heat and hot water if that stuff was included, because you have rights. And once it's been established that you have rights, even though that these are rights that were established, they were given to you by the owner in this written document, those rights were conditionally given to you. And there's an expiration date on those rights upon the termination of the lease. Now, so your rights can expire earlier if you violate the terms of that lease. Those rights can be revoked, but only can be revoked by the court if it can be proven you violated the terms that gave you those rights to occupy those premises. And that's what the process of eviction is. Anyway, so let's do the highlights here. And there are 4 leasehold estates that we're going to discuss in chapter 12. Estate for years, periodic estate, tenancy at will, and tenancy at sufferance. Those are the 4 types of leasehold estates that we're going to go over in a much later chapter. And just to give you a quick definition of them, an estate for years need not be for a period of years. Its distinguishing characteristic is that it has a start date and an end date. You know when the lease term ends. So it's for a fixed period of time. It could be for a month, 3 months, 6 months, a year, 2 years. Its distinguishing characteristic is you know when it begins and you know when it ends. So that's why I said it doesn't need to be for a period of years. So don't let the name fool you. And that's your typical lease. A periodic estate, also known as a leasehold from period to period, is a lease that instead of having an expiration date in it, it has a renewal date. So this type of lease will automatically renew for the same length of time the original lease was written for. Whether it's month to month or every 3 months, 6 months, year, 2 years, 5 years, unless you give the landlord notice to quit that you're not going to continue the lease, it'll automatically re-up. It'll automatically renew for similar succeeding periods of time. A tenancy at will is unique. You're allowed to be the tenant there. You're allowed to continue renting at the landlord's will. There is no definitive, it's for an undefined period of time. Because you're allowed to continue renting there until the landlord says you got to go. However, they will give you a 3-month notice to quit, that you got to go. Okay. This is unique. It's usually used in times like when the state's notified the owner that they're taking their property by eminent domain. But that could be a year from now. Who knows when it's going to be? In the meantime, the owner still has to pay their mortgage. They still need to pay their taxes. So they're allowed to continue renting it. But how could you write out a lease to a tenant if you don't know how long you're going to be, when the state's going to demand the property, you turn it over? But they will give at least 3 months notice. And when they do, you could tell the tenant and then the tenant got to go. So this is why a tenancy at will is ideal for this situation. And then you have a tenancy at sufferance. This is when a tenant had a lawful, valid lease at one point of time. This is not a squatter or squatter's rights. Tenancy at sufferance is when a tenant had a valid, lawful lease. The lease expired. The tenant's not paying the rent. They didn't move out. Every day they remain, they cause the landlord to suffer. Thus, the tenancy at sufferance. Okay? So we'll go over that in chapter 12, but I just gave you the quick rundown on the definition of those 4 leasehold estates. Oh,
What's the next step of tenancy at sufferance? The tenant's not paying rent and,
they can be evicted at any time.
oh, okay. fine.
Any
Can you,
tenant,
or you could put a new or you could put a new lease in place.
sure. Yeah, the landlord could accept the holdover tenancy, but why would you? The tenant's also not paying rent.
Yes, but let's say somebody has, a lease that doesn't have a defined amount of time. At any point, the landlord could come ahead and put down a lease with an expiration date.
No, a lease is a contract, and there's 2 parties. Both parties need to agree to the terms of any contract. Landlord can't just make changes.
No, but could they present a lease even, let's say a lease expired, September 2021, and the tenant is just living in there and he's paying his rent. But
Okay,
then, after a certain amount of time, the landlord says, hey, I want to increase the rent or something. So they come up and say, hey, you had a lease, we never renewed it. Now we would like to renew the lease with X amount of dollars.
yes, because now that tenant is on it's not a tenancy at sufferance, okay, first of all.
Right,
But
right, right, right.
but they can renew when the tenant is now a periodic tenant from month to month. Okay, so you have to give them a notice. Say, no, the notice has to be served 30 days before uh, the next payment is due. So when they make one payment, it has to be at least a month's notice that you need to serve them. If you serve, if it's like you tell them you have this discussion in the middle of the month, you got to wait till so the next payment is done and then give them a notice of a month. So basically, you got to give the tenant the notice that we can't operate without a lease here, and so therefore you either have to agree to sign another lease or you got to go. I can't keep you on as a month-to-month tenant. I need you to sign a year-long lease or whatever the term is that you want. And if they don't agree to it, here's your 30-month notice to quit, to get out. You're not renewing their month-to-month tenancy. So month-to-month requires 1 month's notice to quit. Okay?
Now, I have a question about
Yeah.
that. Because my mother was going through something similar with her tenants. And she gave them a notice and gave them plenty of time in advance to move out. And it was kind of like, oh, well, we still don't find a home to move out to. And
Not your mother's problem. Yeah, who's the landlord, right?
yeah,
Yeah, that's not your mom's problem. That's their problem.
and then they decided to live a month free because of the deposit.
No. That's not what a deposit's for. Deposit's for damages.
Yeah, that's what I,
Unless unless your mother had it specifically written in the lease that if the tenant doesn't pay the rent, that they're authorizing them to use that, keep the security deposit as the last month's payment. If they,
no, I know she doesn't, but
But
that was what happened.
but that kind of screws her up too, because what if they also didn't? What if they also have damages? Now there's
Yeah,
no,
exactly.
So that's why those security deposits should not be used as the last month's rent. Okay, often with deadbeat tenants too, they usually don't take care of the premises. And usually when they get out, there's all kinds of damages that may even exceed the security deposits. And God forbid they're malicious. I used to be a superintendent of an apartment building. I've dealt with tenants before, but also as a real estate agent. I had one landlord that took them forever to get a tenant out, and then when they got out, there was garbage all over the place. There was, it became the Roach Motel. There are holes punched in the wall, and there was an awful smell in that apartment. Awful, it was disgusting. Couldn't figure out where it was coming from. I got a pretty sensitive nose though, so I kind of tracked it down for him. I needed a step ladder though to get into it because I eventually found where the smell came from. The the tenant, in the closets, the closet space, in the closet, there's usually the hanger for the clothes, and then above that, there's usually a shelf. Well, at the back of the shelf by the wall, towards the bottom, they punched a hole in the wall behind it, and they threw a bunch of dead fish back there. That's where the smell was coming from, rotting fish behind the walls. Yeah.
So what the purpose of that?
To be a dirtbag, I guess. These are people with no morals. These are scumbags. They're not good people. Yeah, this is one of the things you got to deal with when you're dealing with tenants. Sometimes you come across.
You can't run. You can't be prejudiced to a criminal background just in case you've had someone file a complaint against you like that.
Yeah, but you could. The only recourse of the landlord in this case is you'd have to find them and sue them. That's exactly they got no money anyway.
Well, that's why she's not even going after them for the deposit, because she just wants them out because they're kind of malicious. So she's worried about what they can do, and since she's alone.
Some landlords go as far as paying the tenants money just to get the hell out quickly.
Yeah.
But I'm not giving you the money until you're all packed up and you got your crap out. You could have an agreement like that. But okay, that's chapter 12 where we talk about the leasehold and tenant issues. Okay, so let's not get hung up on that. Okay, so we're talking now about the 3 types of freehold estates. Okay, let's do all these highlights, and then we're going to get in the underlines and the notes that I wrote here. And then on the coming slides, we'll have one slide for each one of these. We'll address them on a case-by-case basis. So just do all the highlights right now and the notes, and then we'll get into each type of estate. Let me know when you got it.
Yeah, I have been.
That was quick.
Got it.
Not yet, almost done.
Yeah, okay.
All right, finished.
All right. Anybody else still taking notes, or everybody else done?
I'm good. I'm good too.
Okay. So the three types of freehold estates, we'll do a little recap of them here. We have fee simple. It goes by three names. Fee simple, or fee simple absolute. This one type of estate can go by these three names. Fee simple, or fee simple absolute it is the highest form of ownership recognized by law. It's the most complete form of ownership. It's ownership forever without any restrictions on it, on that ownership. Then we have fee determinable estate. Also goes by three names: fee determinable, defeasible fee, or conditional fee. All three of those mean this is describing the same type of estate and land. It is also ownership forever. However, that ownership is not a restriction. The restriction is called, any restriction placed in deeds are called restrictive covenants. The word covenant is a legal promise. So this so happens to be a restriction on the deed, so it's a restrictive legal promise that's written into the deed itself. Only private parties can place restrictions in deeds. Government cannot. Government has their own powers that they could use to limit how you can use your property. So restrictions can only be placed in deeds by private parties, by owners of property when they sell their property, not by governments. Governments have their own powers on how they can limit the use of your property. Now, if the restriction is violated, the ownership would revert back to the person who placed the restriction in the deed. This is known as the possibility of reverter. So if that restriction placed in the deed was violated, the ownership can revert back to the person who placed the restriction in the deed, or their heir, or to a remainder man. That's a third party named in the instrument to be the beneficiary in the event that that restriction was violated. The restrictive condition runs with the land, meaning once it's created, it passes on from one owner to the next, and it cannot be removed by anybody. When you sell a property, you can't add additional rights that you did not have. You're just passing on the rights that you purchased. You got with the ownership of the land when you purchased it. And those rights may have already been restricted. If they were restricted, well, you own that land, and that's all, the only rights that you could pass on are the ones that you got. You can't create any new rights for people. You can only pass along the ones that you have. So if the ownership rights were already restricted on that property in some way, then when you sell the property, the next owner passes on to them. That's what the term runs with the land means. So the restriction passes on to the next owner and can only be removed by the person who added the restriction to the deed, their heirs, or by a court. However, it's unlikely that a court will remove those restrictions unless it turns out that they are illegal, like discriminatory restrictions, for instance. And then lastly, we have a life estate. A life estate is a form of ownership based on the life of the person the estate is measured against. They can't leave it by will, and they have all the rights of ownership. They could sell the property, lease it, mortgage it, give it away, but they can't destroy the estate's value. Because upon their death, the ownership reverts back to the person who gave the estate, or to a remainder man or their heirs. An example where this actually took place was, you guys remember Hugh Hefner, the owner of Playboy magazine? Wasn't that long ago that magazines existed, right? Anybody remember that? Hugh Hefner?
Yeah.
Familiar?
Yeah.
The owner of Playboy magazine? He was the ultimate playboy up into his 90s. Well, Hugh Hefner, he actually sold the Playboy Mansion. Did you guys know that? Let me see if I got this on a coming up slide at all. Oh, I never did. Should have taken screenshots in that. I think I will in the future. But let me click that, and I'm going to open up the browser window. Okay. And let me just share this with you. Give me a second here. Because now I got two browser windows. Okay, give me one sec. Yeah. Oh, what happened? No. I think this website actually removed that link. This is realtor.com, actually. A link to, oh, no, there it is. Thank goodness. Yeah, get some screenshots of this before they do. There we go. How do you like this? For sale with owner. When Hugh Hefner sold the Playboy Mansion, he put a condition in there that he would be given, he sold it to somebody, his neighbor actually bought it, with a condition that they give him back a life estate. So in other words, I'm going to sell you my property if you give it back to me, if you give me ownership back, so that I could be here for the rest of my life. And then when I die, then you get the property. That was the condition of the sale, of the life estate sale of the Playboy Mansion that Hugh Hefner sold. This is actually a picture of the Playboy Mansion, and this is for sale with owner. Somebody put that sign up there. That's pretty clever. So the Playboy Mansion was actually in really horrible shape. You know, it was constant partying all the time for decades there. This constant partying all the time, no time for remodeling or redecoration or anything. You have to have those three little dogs that peed and crapped anywhere they wanted. So it was said that the Playboy Mansion stunk, and it had a lot of it was old decor, old carpeting, old, it wasn't really maintained. So it was in horrible shape. So why did Hugh Hefner sell the Playboy Mansion before he died? Why did he sell the Playboy Mansion? And with the condition that he gets a life estate back. Why would you imagine he sold it? Come on, give me some ideas here.
So I could get some more money?
Yeah. Yeah. With the advent of the internet, people get their porn for free online. Oh, I know. People got Playboy magazine for the stories. I know. So, yeah, it's expensive to live a Playboy lifestyle, and especially when you have ex-wives that you give yachts to. Yachts need to be run by a crew of people. When you've got chefs 24 hours a day on standby, when you're constantly running these parties and having all the bunnies and guests and everything, it's expensive lifestyle to live. And he lived it his entire life. He enjoyed his life. There's no doubt about that. But Hugh Hefner was broke towards the end of his life there. And well, broke, relatively broke. Let's put it that way. He was Beverly Hills broke, okay? Because this estate was in Beverly Hills. So he was still rich by our standards, but by Beverly Hills standards, uh, he was basically broke. So he sold the Playboy Mansion so that he could get the money, especially since he had his daughter. He actually retired a while ago, and he put his daughter in charge of running Playboy magazine. The uh, Playboy Incorporated was run by other folks, which had Playboy TV and the websites and all that stuff. Playboy Hugh Hefner was making most of his money off of trademarks, like the bunny that he licensed out for car air fresheners and things of that nature, the Playboy bunny image, and his daughter was still making money and still managing Playboy magazine, but saw that she wasn't going to do this for the rest of her life, and saw that magazine industry was pretty much dying off for that, as people starting to switch to online to get their pornography and stories, their news. So she got out of it, and then Hugh put his son to run Playboy magazine. And they live out there in Beverly Hills, California. His son, ultra progressive, had the idea that he thought it was going to be fun for the first magazine publishing that he does. Wouldn't it be so fun if we changed the spread, the layout spread for the Playboy magazine, for the centerfold? Our first one that I do when I run the magazine and take it over, to be a transgender. So imagine the shock of the readers who subscribe to Playboy magazine to basically see a naked guy spread out there, and that's basically what they got. So their subscriptions dropped like crazy. They were losing money hand over fist even more now. He pretty much put the death nail in Playboy magazine as a magazine itself. So he sold the property. Now, he sold it in hopes to get upwards of $200 million for it. However, it was a 29-room, 6-bedroom Beverly Hills mansion in decrepit condition. Okay, hey, you leave that Playboy bunny lifestyle. So Hugh Hefner was 89 years old when he sold the Playboy mansion, with the condition that he get a life estate that he can live out the rest of his years in his beloved estate. And it ended up selling. They estimated it was going to sell for 80 or 90 million. I think it ended up selling for 100 million. Hugh gave that condition that he gets back a life estate. He can live out the rest of his years there. While the person who bought the estate from him for $100 million and would only get possession and ownership of it when Hugh Hefner dies, actually did a pretty good deal, because he got it for $100 million, and Hugh Hefner ended up living only one more year. He died the next year. So he didn't have to wait that long to get the ownership of the Playboy mansion. And if you look at it online, there was also conditions in there that he couldn't tear down the building or anything like that. So instead, the new owner started a massive restoration project because of its historical significance. I mean, you had presidents from the United States and other countries and movie stars, and there was a lot of history there at this Playboy mansion. So they're redoing the entire building of that Playboy estate. But this is a perfect example of where life estate would come into play. So Hugh Hefner sold that Playboy mansion on the condition that he was given back a life estate. He got that life estate, was allowed to live there for the rest of his life, and he died the next year. So then the ownership reverted back to the guy who actually gave the money to purchase it for $100 million. All right. Now there's also another twist on a life estate called a life estate por otra vía. I know some people sometimes in French, they're like, that's French. No, it's not. It's Latin. I know the same term is available in France, in French language, but this is Latin. These terms are all rooted in Latin that we're learning here, the legal terminology. If it was French, pour would be spelled P-O-R, not P-U-R. Okay, so this is Latin. Pour vie. It's pronounced the same, but it's Latin. It means for the life of another. So a life estate, pour vie, is not based on the life of the person that it's given to, it's based on someone else's life. So you can imagine different scenarios where this could possibly be used. So this would be a life estate pour vie. You need to know that term, pour vie, for the life of another. It's not based on the life of the person it's given to, it's based on a third party's life, someone else's life. Alrighty, I'm gonna get my snippet tool, snap picture. This one, actually, no, I'm not snapping a picture. We're just getting the slide information. I'm gonna put down the whole states. Yeah, and all the notes. There you go. So, once again, fee simple. It goes by the name fee simple, and fee simple absolute. It's the highest form of ownership interest recognized by law. It is unrestricted ownership forever. The holder is entitled to all the rights in the property, and on the owner's death, the estate passes to their heirs or devisees. Let me copy that one, not that one, because I don't think I had that in my notes. All right. Then we have the fee determinable estate. Also goes by defeasible fee and conditional fee estate. Because this is a form of ownership that's based on a condition. If that condition is defeated, the feasible fee, ownership can revert back to the person who put the condition in the restriction in the ownership. So it's ownership forever, but that ownership is based on a restriction. If the restriction is violated, ownership reverts back to the person who put the restriction in the deed. But it also has the possibility of reverter, that it would go to a remainder man, which is a third party named in an instrument to be the beneficiary. The restrictive covenant runs with the land, meaning it passes on from one owner to the next, and it can never be removed except by the person who put the restriction in the deed, or their heirs, or a court. But a court is highly unlikely to remove the restriction unless it is illegal. And then we have the life estate. Once again, it's limited to the life of the specific person that it's given to. Ownership would revert back to the person who granted the life estate, or their heirs, devisees, or a remainder man. A life estate can be tied to the life of a third party, called a life estate pour vie. The holder of a life estate has true ownership of real property with all the rights and benefits for their entire life. They could sell the property, they could lease it, they could give it away. But on their death, it reverts back to the person who gave them the life estate. Wait a minute. So then if they sell the property, what are they selling? They're selling their life estate. They're selling you the real estate, but what does the person who buys real estate from someone who's only holding a life estate get? they get the ownership of the real estate that's based on that person's life. So if they should drop dead tomorrow, the buyer loses the ownership.
So, in which condition this life estate sale is happening? Is it happening or it's only for the paperwork?
No, life estate is, if I gave you a life estate of my property, I'm giving you the ownership of my property. You can live in it, you could sell it, you could mortgage it, you could give it away, but you cannot destroy the value of a life estate.
So on the condition of mortgage, if I buy my life estate mortgage property, and then I took a mortgage, and then if tomorrow the person died, then who gonna pay the mortgage?
To pay it off, because you can't destroy the value of the life estate. You can't skim off the value either, it needs to be paid back. Just
Okay.
like you need to pay the taxes, because if you don't pay the taxes, you risk the owner, whoever it's back to lose it. But the thing is, if you try to get a mortgage on a property that you only own for as long as you're alive, do you think your lender's going to throw in a couple conditions in there?
Yeah, they will also put all the conditions.
Because the ownership, they can't foreclose on the next person, because the
Yeah.
ownership that you had, they're lending you money based on the ownership. This is why lenders usually require you to get a title search to make sure there's no outstanding liens or restrictions on the property. You think a life estate is a restriction on a property that a mortgage company would want to know about? Oh yeah, because if you die, the ownership goes back to the other guy, and he doesn't have to pay that mortgage. So you or your estate would. They can't take it out of the property. So the life interest may be sold, leased, mortgaged, or given away, but it always ends on the death of the person against whose life the estate is measured. It cannot be left in a will to devisees or heirs. This is unique. This is one of the three freehold estates where it cannot be left in a will. It cannot be left in a will because upon your death, you lose the ownership. Interesting concepts, right?
Yeah, really is interesting.
Yeah, it's like, who the heck was doing this stuff? But you know what? Life estates are old. They've been around since the beginning of time. Life estate. They can be useful in certain circumstances, but they're not very common, but they're around. I showed you the one with Hugh Hefner and his life estate, right? So let's do the highlights now for the life estate part, because we didn't get those in yet. Life estate is ownership based on a life. It's limited to the life of a specific person. And the owner of a normal life estate does not have the right to pass ownership to their heirs, because the life estate ends on the death of the owner. So it does have a reversionary interest where the ownership reverts back to somebody. And then on page 105, we have the life estate pour autre vie, for another's life. And the holder of a life estate has true ownership of real property, though. However, they can't waste the property. That is, the tenant cannot perform any acts that would permanently harm the land or the property or destroy its value. A life tenant is entitled to all income or profits arising from the property if they were to lease it out. They are responsible for paying taxes on it, though, because that could destroy the ownership altogether. Because two things are certain in life: death and taxes, and the government will step in, and they could, if the taxes aren't getting paid, and they could take it over right away, right? If your taxes aren't being paid, they could foreclose. So life interest may be sold, leased, or mortgaged or given away. but it always ends on the death of the person against whose life it is measured.
At the same time, if I purchase a life estate, but I died before the person I purchased, so again it's go back to the original owner.
Wait, who are you in this scenario?
So scenario is that I purchased a property that is with the life estate. Means the owner has the life estate. He given me the life estate
Okay.
until I purchase.
Yeah.
So it's saying that if that person dies, then again it's go back to them.
Yes.
So if the purchaser itself died before him, the owner, then again it go back to him.
It still goes back to them.
Oh,
But
okay.
but they're dead. So who gets your stuff when you die?
So it's-
Someone you named in your will or
People you know, right? So it goes to your heirs or devisees.
Mhm.
You don't get to keep it just because that other guy died. You don't get to keep it and give it to your heirs. Life estates can never be will
Mhm.
because your ownership interest ends on your death. It reverts back to the previous owner, regardless if they're dead or not, because then it would go to their heirs or devotees.
Yeah. Yeah.
Okay? Everybody got these notes?
I did. I already have this.
Yes.
Okay. So here's the way that reversionary interest works. You have the grantor, because when you sell property or give it away, you're granting your ownership to someone else. So the grantor is the owner. So the grantor gives the title to a life tenant. And when they die, it reverts back to the grantor. So, but if they're dead, it would go to their heirs or devisees or the remainder man if one was named. In that case, that person, it would work like this. The grantor gives you the life tenant, the estate. Upon their death, it could go to a remainder man or devisees that would be named in a will, heirs or devisees. So these are the different ways that could work. Let me try to get a screenshot of this for the notes. Come on, snipping tool. There we go. Bing, bing. All right, so dower and courtesy. If you recall, dower begins with a doe. And what's a doe?
Yeah, it's a husband is dower.
female.
The lady.
Person.
A doe is a female deer. Remember, a doe is a deer, a female deer. What song is that from? Like Sound of Music or
Yes,
something? One of
Yes,
the,
that's the movie Sound of Music.
yeah, it's one of those old movies. But that's how we remember that the dower is the female, the wife's rights, and courtesy, because men should be courteous to women, is the husband's right and the wife's estate upon her death. So, dower and courtesy are ancient rights that a spouse has in their spouse's property. Dower is the wife's interest in her husband's estate upon his death, and courtesy is the husband's interest in the wife's estate upon her death. And New Jersey abolished the creation of any new dower or courtesy rights as of May 28, 1980. Instead, now they give both husband and wife joint possession of the property that is their main marital residence. And then I have a little note here that property acquired before this date gives the surviving spouse a life estate in all the real estate that's owned by the deceased person, no matter what other provisions are made for in the will. In New Jersey, children may be disinherited, but the surviving spouse is entitled to at least 1/3 of the estate. For all property acquired after May 28, 1980, and the determination of the augmented estate is a complex calculation. If the required minimum is not left to the surviving spouse, the courts may grant 1/3 of the estate to them by the right of election. This is just information for you guys. You don't need to know it for exams. What you need to know for exams is dower and courtesy rights were abolished on May 28, 1980. You need to know what dower and courtesy rights are and which one is the wife's right and which one is the husband's right. Okay? So let's do those highlights now in the book on page 105 and page 106. You do that and I take my notes. Okay. Encumbrances. Okay, let's stop here. Don't even look at the book. Don't look at the book. Don't look at the book. If you don't look at the book, I'm going to teach you how to remember this. I'm going to teach you how to remember it really easy. Don't look at the book. Does anybody know what an encumbrance is? Forget about real estate. Forget about real estate. Just the word encumbrance. Have you ever heard this before in your lives? Do you know what the word encumbrance means? Not pertaining to real estate. If something is encumbered, what does that mean? You have an idea? Anybody? An encumbrance is something. Go ahead.
I've heard of it like an inconvenience to something, like,
It's definitely an inconvenience. That's for sure. An encumbrance is something that holds you back, that holds you down. It's a burden. Here, that's a better word. An encumbrance is a burden. So an encumbrance is a burden on the property. Claims, liens, charge, or liability attached to and binding on real property, limiting its value or title. Now, forget about real estate again. If you're burdened by my weight, if I were to jump on your back, are you burdened by my weight holding you down?
yes,
Yes.
Yeah.
Can you still move around? If I'm holding you in the back, if I jump on your back like a jerk and I'm holding onto your back, you're burdened by my weight, but can you move around?
Yeah.
Everybody? Can you move around still?
no,
You'll probably be able to move around. It's just going to be a lot harder to, right?
Yeah, it's harder.
Burdened by all that weight holding you down because this jerk jumped on my back. So if I jump on your back, you can move around. It's just a lot harder to. So using that same type of thinking, if real estate is burdened by something, can you still move it? AKA sell it? Yes, it's just harder to. So we're going to use that same scenario of me jumping on your back, you being burdened by my weight. Can you still move around? Yeah, but it's a lot harder to. So let's shift it now to real estate. If real estate is burdened by something, can you still sell it? Sure, it's just a lot harder to. So once again now, an encumbrance is the burden on the property. It's usually a claim, lien, charge, or liability attached to and binding on real property, limiting its value or title. But can you still sell it? Sure. It's just a lot harder to. So liens are financial claims on property. We got mortgage liens, tax liens, lawsuit judgments, and mechanics liens. A mechanics lien is a contractor's lien. If you didn't pay a contractor for work that they did on your house, they could record a mechanics lien on your property. Then we have physical or usage encumbrances, because liens are financial encumbrances, but we could also have physical encumbrances on the property or usage limitations, which are encumbrances on the property, like deed restrictions or easements, licenses, and encroachments. Those are physical and usage encumbrances. Here's a little brain teaser for you. All liens are encumbrances, but not all encumbrances are liens. That's true. Let's translate it in our head so that we don't get mixed up. All financial claims are burdens, but not all burdens are financial claims. You see
Yeah.
how I translated that in my head, made it a lot easier to understand. No longer a brain teaser. That's the approach you should take when reading questions on exams and answers in some cases. Try to translate these new terminology into plain English that you could understand better, So let's do these highlights now that say the same thing.
Yes, done.
Okay. So let's do these highlights. A lien is a claim against property, provides security for debt or obligation of the property. If the obligation is not repaid, the lien holder or creditor has the right to have it paid out of the property, usually from the proceeds of a court sale. Real estate taxes have first claim against the proceeds of such sale because two things are certain in life, death and taxes always jump to the head of the line. They always get paid first in the lien repayment order. So liens are classified either as voluntary, those are liens that you wanted, that you went out of your way to get, or involuntary, those are liens you never asked for, you don't want, but you still got to pay them. And liens can be general or specific. General liens are liens that affect all property you own, and specific liens only affect one parcel of real estate. Involuntary liens are created or imposed without the consent of the owner. General liens, they affect all your property, not just real estate, your personal assets as well. Specific liens placed against one parcel of real estate only. Everybody good? Everybody got the highlights?
Yeah, I'm good.
Yes.
I got them.
All right. So A lien is a financial claim against property that provides security for a debt or obligation of the property owner. A voluntary lien is created by the owner. Involuntary lien is created without the owner's consent. General liens affect all the property you own, both real and personal property, and specific liens only affect one parcel of real estate. So what are the effects of the liens on a title, the ownership? The owner is still free to sell to someone who's willing to take the encumbrance along with the property. Encumbrances, liens and other kinds, they run with the land. They go with the real estate and they're still binding even after a sale. So liens attach to properties, not the property owner. Okay, so liens run with the land, they go with the real estate and are still binding after the sale. But liens, except property taxes and special assessments, do not survive foreclosure. They get wiped out by a foreclosure sale, except for property taxes and special assessment taxes, tax liens. So liens attach to the property, not to the property owner. And although in most cases the next owner is not personally responsible for the debt secured by the lien, you can lose your property if the creditor took court action to enforce repayment of the lien of that financial claim by foreclosing. Yikes. Now, here, I wrote a note down here for you. Taxes get paid off first in the event of a foreclosure sale. If any money is left over, liens get paid back in the order in which they were recorded until there's no money left to pay off any other liens that are on the property. In some cases, if a property owner is in danger of foreclosure, were to sell their property, which had a lot of equity, they could have paid off all their debts and still walked away with a nice profit and keep their credit in good standing. However, sometimes people fall on hard times. They let problems sort themselves out and foreclosure happens. If there are enough proceeds to pay off all the debts, then the homeowner will still get the remaining money back. The lender who foreclosed cannot keep it. If they sold it themselves, they would have received more money at the auction. I'm sorry, then an auction sale, right? So a lot of times people, when they fall on financial hard times, they sometimes, the stresses are falling on their shoulders. They stop opening up the bills because they know they don't have the money to pay them, but they know it's a bill or some kind of collection letter, or even letters from the courts, and they stop opening them. They throw them in a pile, right? But if they were to actually take the bull by the horns and say, listen, I could try to get ahead of this. I'm going to lose my house, no doubt. I got to come to that realization. Let me try to sell the property. If I sell it, I have a lot of equity in it. I almost had the property paid off. I only had a couple payments left, but I lost my job, had medical bills or whatever, and I wasn't able to work, so I fell behind on my mortgage payments there and my taxes, and they foreclosed on me. Well, an owner could have still listed their property for sale and sold it at a profit especially if they almost had it almost paid off. It's almost all profit. The lender only has a small amount, like a couple mortgage payments left, right? So they're foreclosing because they want their couple payments that you haven't been making. So they foreclose on you and sell the property at an auction to the highest bidder. Why do people go to auctions to buy real estate?
To get cheaper.
Yeah, to get a deal, to get it cheaper.
Yeah.
But that property owner, if they were to have sold it, they could have gotten it for a lot more.
Yeah.
They could have gotten a lot more for their property. Your profit. But instead, sometimes people, they put their head in the ground, hope the problem goes away and sorts itself out eventually, and it doesn't. What's going to happen is they're going to eventually get foreclosed on. They're going to sell it at auction. It's not going to get the most money that they possibly could have gotten for it, but they'll still have some profit, possibly. That's a possibility if they had a lot of equity in it. And they will get that money back. It's just a shame that they waited and they didn't know, because they could have sold the property and got themselves a lot more money than what an auction would have yielded. I've done this before for people. I've sold homes for people that they fell behind on their mortgage payments, and they were even getting sheriff's court dates that they were going to have a tax auction on the property. And I told the homeowner, I was like, good thing you contacted me. We could still sell your property, and you could still walk away with a profit if we beat the foreclosure sale. And even if they do manage to do the foreclosure sale, we still got 10 days in which we could close on it, and that would undo the whole foreclosure auction. That would undo the whole auction deal. A lot of people are unaware of this. So, look, if somebody comes to you and they're in danger of foreclosure, you need to know that in advance so that you can list the property at not the highest price, but you could price it aggressively, but more, and still get more than what a sheriff's sale auction would get, right? And then you'd get a buyer that comes in. You could have, you could close on the property, and they could walk away with their profits, a tidy sum, perhaps. Now, how long does it take to close on a sale? Anybody know? When you sell a property, once you get it under contract, how long does it take on average to close?
We did attorney review, but a 3 weeks times to the lender's loan. 3 weeks time for the lender is taking time to background check and all.
Average sale. How long does your average sale take to close?
1 month.
Okay, so let's just say a month or two, even. Okay, we have enough time that we can petition the lender and the court to delay the foreclosure sale. The homeowner can do 2 delays each time for 2 weeks, so they could delay it for a month. And the lender also has that power to delay a foreclosure auction 2 times for 2 weeks each, granting another month, 2 months total. So if we find out that somebody's in danger of foreclosure, but the sheriff's auction has not been scheduled yet, we list that property aggressively for sale to the MLS. We market the hell out of it, trying to get a buyer. We get a buyer. We move through that closing process. We know that we have at least 2 months to close on the deal. Even if tomorrow they schedule a sheriff's sale, we know we got 2 months. We could delay it twice, or we could delay it for 2 months. And even if it takes a little bit more than 2 months, we can still close on the property, because even after there's been a sheriff's sale, you could undo that sheriff's sale up until the moment that that deed is delivered to the winner of the auction, which won't occur till 10 days after the sale. So you have another 10 days even after the auction took place to undo it. And then whoever the winner was at that auction, they'll get their money back that they paid. But you could undo it.
Yep.
Okay. Okay, encumbrances, liens, and other kinds. They run with the land. They pass from one owner to the next. Liens attached to the property, not to the property owner. Real estate taxes are first claims against those proceeds of a sale from the foreclosure sale. Liens, they could be voluntary or involuntary. A mortgage loan is an example of a voluntary specific lien. It's specific because it only affects one parcel of real estate, and it's voluntary because you went out of your way to get it, right? You put in an application, you jump through all kinds of hoops in order to get that loan, which ended up creating a lien on your property. Or a home equity line of credit. That's another example of a voluntary specific lien. Involuntary samples of liens are real estate taxes. Who the hell wants to pay those? Right? They were imposed on you without the owner's consent. But they're specific liens that only affect one parcel of real estate. If you own several pieces of real estate, but you don't pay your taxes on one, they can only touch the one property that you did not pay the taxes on. Unpaid federal income tax or IRS liens. Those are general liens. They affect all the property you own, whether it's real or personal. Your cars, your money, your bank accounts, your real estate, etc. Those are involuntary general liens. A lawsuit judgment can be a general lien that can be used to create a lien on any real estate you own, on your bank accounts, or maybe even your car, or your pet. Unpaid child support's the same thing. It's an involuntary general lien. They're imposed on you. Once you've paid off a lien on a property, you paid off your mortgage loan, for example. Do they remove the lien from the property that was created by the loan?
No.
What do? They actually record another document in the public record called the satisfaction of lien, showing that the lien had been satisfied, it'd been paid off. The reason why they don't remove liens once they've been recorded in the public records, any document, once it's recorded in a public record, it's there forever. It's never removed. It's there forever. They just add another document showing that it's been paid off, so that if anybody ever does a title search, they could trace back throughout history all the previous owners and any liens they had and those liens being paid off, etc. You got a full record of all the documents pertaining to the ownership of that property. So any liens on the property create what's known as a cloud on the title, especially if the owner's not, if the buyer's not aware of them. You could buy a property that has liens on it, but you want to make sure you're aware of any liens that are on the property. So think of that dark thunderstorm cloud when you think of the term cloud on the title. Would you want to buy a house that has a dark thunderstorm cloud hovering only over your house? Picture that when we hear the term cloud on the title. It can mean that there's a lien or some other encumbrance on the property that could threaten your ownership. And we want the seller to clear up any clouds on a title, which could be maybe a previous sale where one of the owners did not sign the documents, or there's a lien on the property, an additional lien other than the mortgage lien that you bought with the house with. So I've had this situation with a girl I know. She bought a house, and when she was selling it, she had some trouble selling it because when she bought it, you know that she has a lien on the property for the loan that she didn't pay off yet, but she'll pay it off with the proceeds from her sale. But the previous owner's lien for the mortgage he had was still listed as being on the property, attached to the property. But she knows that was paid off when she bought the house because her mortgage loan paid off that mortgage loan. However, that guy's lien holder, when it was paid off, never filed the satisfaction of lien in the public records. Her attorney should have made sure that that got done. But he didn't. So now she's trying to sell it years later, and it's still showing that there's that lien by the previous owner, their mortgage company. So what should she do? What would you do?
You're trapped, basically.
Are you?
Or find a good lawyer.
Okay, well, let's just, before we jump to that, who had to file a satisfaction of lien?
And the title agency.
The previous guy who owned the property, that was his mortgage loan.
Yeah.
So when his lender got paid back all the money from the proceeds when she bought the property from him,
Mhm.
their lender should have filed a satisfaction of lien in the public record saying that the loan was paid,
Is paid. Yeah.
but they didn't. So now what should she do?
Contact the previous owner.
No.
She doesn't know where he is.
Yeah.
So what should she do now?
She can go to the title agency go to the broker. The broker has to transfer the money to the previous lender.
How about contact the previous lender?
Yeah, previous lender.
Hey, you were supposed to file a satisfaction of lien and you never did. You got paid off.
Hmm.
So that's the first thing she did. They went out of business.
Oh, that lender out of business. Okay.
So now who do you contact to try to clear it up?
Lawyer.
A lawyer? You saying lawyer?
The person who paid off the lender.
Try to contact. I mean, you could try to trace down, whether it's you or the lawyer doing it, who the lawyer contact to try to clear it up.
The company that paid off the lender.
Well, they could only prove
Or
that
the
they
mortgage company.
payment in, but ultimately it's that lender who got paid to say that they actually got the payment and that it was paid off. Hopefully, maybe she got title insurance, and the title company would ensure that these liens would get paid off. That
Yeah,
there
there's,
were
when I was saying
liens.
broker, that means that title insurance. Yeah.
But before you even go to that point, like Brian was saying, why doesn't she contact her own lawyer and say, listen, I got this problem going on. I paid off that other loan, and when I bought the property, he paid off that loan, but it's not showing that it was paid off. And the lien and the mortgage company went out of business. So what do we do? Her lawyer said, that's your problem.
Damn.
Damn, it's pretty cold, right? He said, that's your problem. And she's like, well, wait a minute. Can you at least give me the documents when I bought the title insurance? I don't see them in my closing documents anywhere. Can you at least send me over a copy of my documents from the title insurance that I paid for? He basically hung up on him. And I told her, well, you know what you need to do? Get a lawyer to sue your lawyer. So she tried reaching out to a couple lawyers. None of them were willing to. You know why?
Lawyer to lawyer.
Well, no,
And
suing each other. Lawyers don't have a problem suing each other. But how come she couldn't find a lawyer that was willing to sue her old lawyer who's so brutal like this? Well, because now he's a New Jersey Superior Court justice.
Oh.
And none of them want to risk appearing in front of him at some point in the future and Yeah, hey, you're the lawyer that sued me. So yeah, I thought she couldn't find a lawyer that was willing to sue him. So I was like, well, then you need to go to the attorney general and file a complaint against the judge, you know. But apparently, you got to, if you're going to file a complaint against a lawyer or, with the bar association or any of those things, you got to spend thousands of dollars on that to file a complaint. And then that stays on his record, and then his insurance goes through the roof once they get 3 complaints on their record. So they don't want that. But so she didn't have the money though to spend on that, and plus that doesn't help her with her situation any. So the attorney general, she didn't even go that route. I don't know what they did, but she hired a new title company to try to clear it up. And they eventually did. Took 2 years.
Mm.
So her buyer didn't stick around. So she had to put it back on the market after they eventually cleared it up and then get another buyer and then go through the whole thing. But it delayed her moving and selling her house by 2 years.
Wow.
Because somebody failed to do their job. So don't always assume that attorneys and mortgage companies and title companies and everybody's doing their job. You need to, if you're the property owner, you need to follow up and make sure that all that stuff got done and you got all your paperwork in order. Not just, hey, we went to the closing and we signed all the paperwork and I moved or I bought a house. Make sure everything was buttoned up.
Mm.
Our job as real estate agents to do that because we don't do any filing of paperwork in the public record. But we should advise our clients at least to, make sure that those experts, your attorney, actually does their own job because sometimes they don't, and it could be a nightmare if they don't. All right, so let's see. That was the encumbrances there. We did that. And we already went over this involuntary alienation from chapter 20.
Agree.
Who gets a property and what's the process to get the property? Person dies without heirs, they die intestate, it escheats to the state, land's needed for a greater public good. Certain government and quasi-governmental agencies and utility companies have the powers of eminent domain. They could take your property through the courts, but they have to justly compensate the property owner for that. And then the public agency or governmental agency or utility company gets it. Non-payment of debt secured by real property. Well, foreclosure occurs and then the sheriff sells the property to the highest bidder. And then through open, notorious, continuous, hostile, and adverse use of another's property for a prescribed period of time, as prescribed by state law, an easement by prescription can be claimed through adverse possession, a suit for adverse possession, sometimes also called a suit to quiet title. The adverse possessor would then get the property. So, what determines who gets paid first in the event of a foreclosure? Well,
Tax, real estate tax first.
taxes jump to the head of the line always. But the priority of liens are determined by the order in which they're recorded in the public record, according to the date of recording in the public record, with the exception of only 2 things. Real estate taxes, because they always jump to the head of the line, because 2 things are certain in life, death and taxes. We're all going to die, and we all need to pay taxes. Even after you die, you got to pay your taxes. Through probate, right? And a mechanics lien, that's a contractor's lien. They're unique in that they're not dependent on the date that they're actually recorded in the public record. They could be backdated to the date that the materials were delivered or when the work began. So they could actually jump ahead. They could be recorded later and still jump ahead of other previously recorded liens because they could be backdated. So let's do that highlighting about the priority of liens getting repaid. and what determines the priority.
Done.
Yeah, got it.
Okay. So, what are the effects of the liens on a title? We know that liens and other encumbrances run with the land. They pass on to the next owner. Liens attached to the property, not to the property owner. So would you want to know about any liens on the property before you bought it? You think
Yeah.
it's about these things? How would a buyer find out?
The title search.
That's exactly it. They would do a title search to discover any documents relating to the ownership of the property in the public records. So priority of liens establishes the order in which liens or debts are repaid. Tax liens take priority over all other liens. Otherwise, they're paid according to the date they're recorded in the public record, with the exception of a mechanics lien, which its priority is retroactively backdated to the date the work began or the materials were delivered, whichever happened first. Mortgage liens and junior liens for second loans or home improvement loans, judgments, which are created, judgment liens are created from a decree from a court saying you owe someone else money. That's what a judgment is. They could be turned into liens against the property. And there's other liens, I guess, out there as well. So let me get that effects of liens on title, and let me add that to the notes. So mortgage liens of, let's do these highlights, page 108. And mortgage lien is a voluntary lien. Construction lien is also known as mechanics lien. They're a form of involuntary lien. And construction liens are unique in that they're retroactive to the date that the work in question originally began or when the materials were delivered.
Yeah, done.
Everybody got it? By the way, let me throw out the attendance poll right now.
Done.
Thank you, everybody.
I have a lot of stories about construction lanes.
No, what's that?
Because my father does home improvements and does construction for homes, right?
Okay.
And a bunch of times we will get people without even letting us know that, hey, I want to get my grass cut for the whole month. I'm moving out to Florida. I just want it cut. And unexpectedly, when we show up to their doors and to get the payment, they're not there no more. They moved.
Yeah.
A bunch of times that has happened to my dad, to me as well. And like whenever we finish painting, whenever we finish extending a house, whatever, they move out.
It's important to get those requests in writing before you say, okay, yeah, we can, no problem. It'll cost this much, and send it in writing, get an email, get something from them. And you know, you send them a bill and have them respond agreeing to it. And then you could also then before they sell the property, you can put a lien on the property if they don't pay them.
And how do you do that, Lynn? Like what you said through email, right? Like,
Well, you could take your bill, go down to the public records, raise your hand and swear an oath that you're telling the truth, and here is the bill. And you could create a lien, you could attach a lien to the property. Now, they try to sell the property, they're not gonna, most likely not gonna be able to sell it, because who's gonna buy a property with these additional contractor liens on it? They're gonna want the seller to pay it first. Otherwise, they're gonna have a tough time selling their property. But it is possible for someone to buy the property with those liens on it. The only difference is, though, they become responsible now for paying the lien. Now, although they're not personally responsible for paying it back, the real estate that they bought is. And you could force repayment of that lien by trying to foreclose on them.
got it.
So you got to go down, you record these liens in the county where the property is located. And you pay the appropriate filing fee. And then they'll guide you through it. Go down to the county clerk's office. They're usually the registrar of deeds in most counties. There's some counties that have a specific person that's their only job that they do. But that's let me open up the slideshow really quick for chapter 21, because I think that's where it's listed. Who is the registrar of deeds? Let me see, let me open up 21 just to look at that really quick. Register recording acts.
Victor, are we gonna finish this chapter or are we gonna end here?
No, we're gonna finish this chapter. Let me see. I better get on it, but yeah, we'll finish this chapter. But let me see, who is the registrar of deeds? Title. I thought it was in chapter 21. It may be, I'm just not seeing it in the slideshow. Let me close that out. We'll come back to here. I think it's at the beginning of chapter 21. There's in some counties, there's a special registrar of deeds assigned for that. Let me see. Yeah, I'm not sure where it is right now. I don't want to waste too much time on that right now. We'll get to it and I'll show you. In some counties, there's a special registrar of deeds that's their only job that they're assigned to do.
If you go to the Google, you can just do the lien record and the county name. It can, like Middlesex County, they can come in Middlesex County. Different county had different website.
Well, some places you go to the county clerk. Other places there's a special registrar, like Union County. There's a special registrar of deeds because it's a densely populated county, and that's someone specifically assigned. That's all they do, is register liens and stuff in the property. All right. So let's continue on so we can finish this chapter today, since we got a half hour left here of class. So everybody got this stuff highlighted?
Yeah.
Yes.
Okay. Let's highlight this. A lis pendens is it's not a lien, but it's a notice of possible future legal action against the property owner or the property. So basically, when you fall behind on your mortgage payments by at least 2 months, your lender is going to they're going to be doing collection calls on you once you're behind 1 month, you know. But when you fall behind in 2 months, 2 months is usually around the time where they record a list pendants in the public record. It basically puts the world on notice that you're behind on your mortgage payments. That's when you start getting calls from attorneys looking to represent you and all kinds of stuff because they pay for a service that lets them know when a document's recorded in a public record for a possible lawsuit so that they could then represent you. You know? So wouldn't it be helpful if you're an investor or a real estate agent to also get a list of these list pendants when people fall behind on their mortgage payments? If you're an investor or a real estate agent, hey, those are possible short sales that you could do. Those are people that may be in danger of losing their property to foreclosure, and you could get to them first before that happens and help them sell their homes. There's one source of where to get listings. I'm just giving you guys some business ideas here. You subscribe to List Pendants list. Okay, so what is a list pendants? It's a public notice of possible future legal action against the property. That legal action being foreclosure. So on the next slide here, I give you a couple of resources of list pendants lists you could subscribe to or get that information from. This one that's free, that's included with your Realtor membership, you could get access to searching tax records, but the first two here, njlistpendants.com and realtytrack.com, these are lists you could actually subscribe to. Realtytrack.com is probably the better of the two. I've never seen the one from the Red X pertaining to list pendants lists, but I know they're great for like searching expired lists. This is a great tool for searching for expired listings and for sale by owners and things of that nature. And apparently they got into the game of selling list pendants lists as well. But list pendants is a public notice of possible future legal action, and you could subscribe to these lists here, and then you could reach out to the property owners. I would suggest doing so by doing a soft approach, sending them a mailing. Don't go calling them. Don't go knocking on their doors, because these are people who are in financial hardship, and you calling them up and saying, according to my records, you're behind on your mortgage payments. They know that already, and they're going to be like, who the hell is this, and how do you know that? You know, they're not going to be happy. Don't go knocking on their door. Yeah, you're behind on your mortgage payments. You know, they may punch you in the nose, you know, but if you send them a postcard that says, behind on your mortgage payments, in danger of foreclosure, we can help. Wow, what great timing that this ended up in the mailbox. It's a soft approach. Don't just send it once. Start sending it on a regular basis to them. And eventually, they're going to break down and realize that they need help, and they're going to eventually call. Okay? But that's a great resource for you right there.
Mm-hmm.
So list pendants, public notice of possible future legal action. That's what that is. You need to know that for exams too. Hint, hint. So an easement is a right acquired by one party to use the land of another for a specific purpose. That's the definition of an easement. Now, once it's been established that people have rights, your rights can't be revoked. So let's write that next to easement on page 109. A right acquired by one party to use the land of another for a particular purpose is an easement. So you're going to write next to the title easement that they are rights and rights can't be revoked.
Yeah.
And an easement is either appurtenant or engross. Those are the two categories of easements. They're either appurtenant or engross. Okay? So what is an easement? Here, let's talk about the utility, the easement in gross first. An easement in gross is the easier one to understand. It's a utility easement, for like power lines, sewer pipes, water, lines, gas pipes, that come to your house. These are public utility easements. Okay. A public utility easement is called an easement in gross. And this is the only type of easement where if the need for the easement were to cease, the easement would cease to exist. So if that utility company did not need to use the land to run their lines or whatever it is on your property, then that easement that gave them the right to have them on your property would cease to exist. So what is the utility easement called? An easement in gross.
Easement in gross.
This is the only type of easement that if the need for it were to cease, the easement would cease to exist. Okay. And then the other category of easements, which is basically all these other easements that we're going to go over now, are called an easement pertinent. So an easement that grants the right of an owner of an adjacent parcel of land is called an easement, appurtenant. An adjacent parcel is your neighbor whose land is touching yours, not the guy across the street or across a stream or river. It's any other property that's abutted to yours, that's touching yours, your neighboring property. That would be an adjacent parcel of land. So for an easement appurtenant to exist, there has to be two adjacent parcels of land owned by different parties, because you don't need an easement to cross over your own land. The tract over which the easement runs is known as a servient estate. They're the servants. They're serving their property on the planet for you to walk over. And the tract that's to benefit from that easement is the dominant estate. They're the one that's benefiting from the easement. The dominant one always benefits from the easement. And the servient is acting as the servant. They're allowing you to walk over their property and use it because they don't have a choice. They have to. Once it's been established, you have an easement right to walk over someone's property. They can't take that right from you. Now they're the servant, they're the servient, and you're the dominant. You're the one that's benefiting from that easement right. And that right runs with the land. So if that property is sold now, the next owner gets that easement right as well to be the dominant estate, that they could still walk over the neighbor's property to use it. All right. So easements are either appurtenant or engross. An easement is a right acquired by one party to use the land of another party for a specific purpose. And we have easement appurtenance. Easements can be appurtenant, or here's some example of easement appurtenance. An easement by necessity, an easement by prescription. Not an easement. We're going to go over party wall agreements, how to create an easement, and how to terminate an easement. So this is all stuff that's Coming up now. All right. So here we got an easement is a right acquired by one party to enter the land of another for a specific purpose. It's usually in writing, it's written into the deed itself, it can be placed on a survey, and these rights cannot be taken away because it's a right, and rights cannot be taken from you. You can give up your rights, but rights cannot be taken from you. And then we have licenses. Licenses are permission to enter the land of another for a specific purpose. That's a license. Licenses can be revoked at any time. Licenses are often verbal. They could be in writing, but they don't need to be. An example is, you're my neighbor. Hi, neighbor. How you doing? Hey, feel free to come over. You could hop in my pool. Use my pool anytime you like. Okay, then we get into an argument. I don't like you no more. I'm not on my damn property anymore. I just revoked your license to enter my property for a specific purpose. It was verbally done, right? You can't use my pool anymore. We got into an argument. I don't like you no more. I don't want to on my property no more. It was revoked just like that. Okay? Doesn't need to be in writing. So just like your driver's license can be revoked, it's a privilege, right? It can be revoked at any time. But rights can't be taken from you. You could give them up. You have the right to remain silent. And if you give up that right, so you could give up your rights, but they can't be taken from. Okay, so let's do the highlights and write that next to there. Easement rights can't be revoked. It's a right acquired by one party to use the land of another for a particular purpose as an easement. And then on page 112, licenses can be revoked. It's permission to enter the land of another for a specific purpose is a license. So the two definitions are very similar. The only difference is one is permission and one is a right. Easements are rights. Licenses are permission. Licenses can be revoked. Easements cannot.
Yeah.
No way, the day's almost over. You know already. No. Let's see. All right. Okay, so easements are the rights acquired by one party to use the land of another for a particular purpose. They run with the land. It passes on to from one owner to the next as the ownership changes. A party could have an easement right in the airspace above the land, the subsurface rights to what's beneath it or in it, like mineral rights. The holder of an easement only has rights, not an estate or ownership interest in the land over which the easement exists. Easements fall into two categories. They could either be appurtenant or in gross, like I stated earlier. They could be appurtenant or in gross. All right, so here's an example of an easement appurtenant. Let's take a look. There's an easement appurtenant, lot owner B on the left-hand side, lot owner A on the right-hand side. Lot owner B has the easement appurtenant to have access to the lake on lot owner A's property. Who's the dominant estate and who's the servient estate in this example?
So lot A is a dominant estate because he is taking the property from lot B to use the lake.
No. Lot B is on the left, lot A is on the right. Lot B has an easement appurtenant so they could have access to the lake that is on lot owner A's property.
Lot A is property, yeah, but it's only the roads, yeah.
So who's benefiting from that easement right to cross over onto someone else's property?
Lot B,
So lot B is the dominant estate
dominant estate, yeah.
and lot A is the servient because they cannot prevent lot owner B from walking over onto their property and using the lake. They have that right to. You follow?
Yeah.
So that's the best way to remember it. The dominant estate is the one that benefits from the easement. The servient is the one who's serving up their property on a platter for you to use. And they cannot prevent you from accessing it. All right. Let me see. All right, here's an easement. You see the utility lines over here, all these poles or telephone poles or whatever the heck they are. They're crossing over two properties over there, but that's the utility company. That's an easement in gross, is an easement for utilities. So that would be an easement in gross. And then we have easement by necessity. When it's necessary to cross over someone else's property in order to gain access to yours. This is known as an easement by necessity. This is a poor example that they give here in this picture in the book for an easement by necessity. I mean, what's to stop you from just cutting down your trees so that you could get access to your own property, you know? Okay, let's just say that we're in some kind of environmentalist utopia where it's against the law, you get the death penalty if you cut down a tree. If that's the case, then I guess this image would be okay, where you get an easement right to cross over your neighbor's property to get to yours because there's no other way to get to your property. This is actually a poor example because most cases you just cut down some of these trees and make a driveway directly to your property. I guess you could say, what if there was a lake or something over here that would prevent it? That would be a better image. Then again, you could always make a bridge. Okay, to get to your property. So an easement by necessity is an easement to gain access to landlocked properties for the purpose of ingress or egress. Ingress means entrance in Latin, and egress means exit. So when it's necessary to cross over someone else's property to get to yours for entrance and exit to your property. So check out this image. This is probably a better image of an example for an easement by necessity. We have lot owner A in orange and lot owner B in green. In order to get access to their property, lot owner B would have to cross over lot owner A's property. So lot owner A has to have a right of way, a driveway or something, or a road for lot owner B to get access to their property. It's so can lot owner B park their car right here in this area on that driveway on that road? No, because it's not their property. They could only cross over it to get to theirs. Now, what if it's snow covered, or a tree falls on it? Who's responsible for clearing it and keeping that road accessible?
Lot owner A?
Yeah, it's lot owner A. Why is lot owner A responsible?
Because it's within their property, they're cut off.
Their
doesn't include-
correct. That's just leave it at that. Don't overthink it. It's their property. That's why. And if they were not to clear it, lot owner B would not have access. So lot owner A is technically cutting off, revoking their rights and you can't revoke someone's rights. So they're responsible for keeping that roadway clear so they have that easement access for the purpose of ingress and egress. Another example is like this. A lot of times you may see this in cities or places where real estate is at a premium, and we have shared driveways where there may be a garage and a parking area in the back of the house. So neither house, they're built so close to each other, neither one has enough room on the side of their house to have a driveway to get to the parking area in the back of their house or to their garage. However, they got a little space, and so does the neighbor. And if we were to put those two spaces together, they could have a driveway. So in this instance, both lot owner A and B are both subservient to states at the same time. Because without the other side, neither one would have the space, the room to get to their garages or their parking areas in the back. This is a common scenario. We see this often. But this is a scenario, too, that we hope you have good neighbors. Because sometimes one may have a little bit more of the space for that driveway is a little bit more space on one side rather than the other. And then that homeowner gets the idea that that's my driveway. It's mostly on my side. I'll put up a fence if you keep parking your car there. You can't park the car there. It's blocking me. I'll put up a fence there and you won't get there at all to your back. No, they can't do that because it's a shared driveway. It doesn't matter the percentage of which one whose property it's on more than the other. Neither one of them can have enough room without the other. But I have seen bad neighbors before where they get into feuds like this, and then one of them drives a spike in the driveway right in the center. Now, the other owner could have taken him to court over that to get him to remove it, because there are easement rights that are established that they could both have access, But you better have good neighbors. Otherwise, sometimes they start feuding over crap like this, Yeah. That could be an issue sometimes. All right. Yeah. So we will actually finish this chapter tomorrow because I forgot altogether that the next type of easement, we're going to have some videos and some more discussion and some more highlights over, and it's going to take longer, even though it doesn't look like there's that much left. There's more conversation involved in it. So we will finish. Yeah, so we'll finish this chapter tomorrow. So we're going to leave off right here on this slide, and let me stop the recording.